Welcome back to LexTalks, Legal Topics Simplified. You know the drill. We break down complex legal concepts,
Mm.
especially for all you law students in India out there. And today's deep dive is into something that sounds a lot more complicated than it really is, marshaling by subsequent purchaser under the Transfer of Property Act of 1882.
Yeah, you're right about that. This doctrine is really all about fairness when it comes to property transactions, especially when mortgages are involved. And, this concept pops up all the time in property law, so understanding it well will really give you a leg up in your studies.
Okay, so let's break
Yeah.
this down for our listeners. Imagine you're a buyer. You're all excited about your new property, but then what if that property has a hidden history, a previous mortgage that could come back and bite you? And that's where this concept of marshaling comes in, like a legal superhero, making sure you don't get stuck with someone else's debt.
That's a great way to put it. Marshaling is an equitable doctrine that courts use to protect buyers, like in your example. It makes sure that when multiple parties have claims on the same property, everyone gets treated fairly. Basically, it's about making sure the burden of a debt is distributed fairly among those who are liable.
So it's
Right.
that's a safety net
Yeah.
for the buyer.
Mhm.
That makes sense. But how does this actually work in practice? What are the legal mechanics behind this marshaling magic?
Well, the core of it lies in Section 56 of the Transfer of Property Act of 1882. Think of it like the rule book for marshaling.
Section 56. Sounds like something that could put you to sleep, but I'm
Yeah.
guessing it's pretty important, right?
Oh, it is. And it might look complex at first glance, but it's not too bad once you break it down. Basically, Section 56 says that, unless a contract says otherwise, the buyer can insist that the lender, the prior mortgagee, first tries to recover their money from other properties that were pledged by the original borrower. So they can't just immediately jump to selling the property you just bought
Yeah.
to get their money back.
So they have to go after other options first, before coming after the property the new buyer purchased. That seems fair. It wouldn't be right for the buyer to be on the hook for the original borrower's debt when there are other assets out there.
Exactly. Section 56 ensures that the prior mortgagee, who has multiple securities, can't just choose the most convenient option for them. They have to exhaust other avenues first to protect the interest of the subsequent purchaser.
Okay, this is making more sense now, but I'm sure there are some, tricky parts to Section 56.
Right.
Legal language can be pretty dense sometimes. What are some key elements our listeners should really pay attention to?
Well, you're right. There are definitely some phrases in Section 56 that trip people up. One of the most important ones is the phrase, "In the absence of a contract to the contrary." This means the right to marshaling isn't absolute. If the original mortgage agreement says that this right is waived, then the subsequent purchaser can't use it.
Ugh. So it's super important for both buyers and their lawyers to really examine that original mortgage agreement, because there could be hidden clauses in there that totally change the game. What else should our listeners keep in mind when they're looking at Section 56?
Another crucial phrase is, "so far as the same will extend." This basically highlights that. The protection offered by marshaling, it has limits. It only goes as far as allowing the prior mortgagee to recover their dues from those other properties. So if those properties don't fully cover the debt, the subsequent purchaser's property might still be at risk.
So it's not a foolproof shield. There are limits to that protection. And what about other parties involved? Does Section 56 consider their rights at all?
Absolutely. Section 56 specifically mentions that the right to marshaling cannot harm the rights of the prior mortgagee or anyone who inherited the mortgage or anyone else with a legitimate claim on any of the properties.
Oh, okay, that sounds complicated. Can we simplify that a bit for our listeners?
Basically, it means that the right to marshaling can't be used if it would unfairly disadvantage anyone else who has a valid stake in any of the properties involved.
So it's like this balancing act.
Yeah.
The law is trying to protect the buyer,
Yeah.
but it also has to make sure that no one else
Yeah.
gets the short end of the stick. It makes sense. But I'm sure it can get messy in real-life situations. So how does all of this play out in a real-world scenario?
Let's paint a picture here. Let's say we have Mr. A, and he owns 3 properties. We'll call them A, B, and C. He takes out a loan, and he mortgages all 3 of these properties to lender X for, let's say, $15,000 later on. He mortgages only property C to lender Y for $5,000. Now, if Mr. A defaults on both loans, what happens?
Well, it seems like lender X could try to recover their entire $15,000 by going after any of the 3 properties. But that doesn't seem very fair to lender Y, who only has a claim on property C.
That's exactly where marshaling comes in. Even though lender Y is a subsequent mortgagee, they can insist that lender X first try to recover the money. By selling properties A and B, lender X can only sell property C if the sale of the other two properties
Right.
doesn't cover the full $15,000.
So even though lender X had a claim on all three properties, the principle of marshaling forces them to go after the properties that aren't pledged to lender Y first. That's interesting. It's like marshaling is acting as a traffic cop, directing lenders towards the most equitable path for recovery.
That's a great analogy. It's all about achieving a fair and just outcome for all the parties involved.
This is all starting to make a lot more sense now. But I have a feeling that things can get a bit more complicated. In practice, what are some situations where marshaling might not be so straightforward?
You're right. Marshaling isn't always a walk in the park. There are a few situations where things can get tricky. For example, what happens if the prior mortgagee has already started legal proceedings to sell the property? Or what if a third party, someone completely outside of the mortgage agreements, has acquired an interest in one of the properties?
Ooh, that does add a layer of complexity. It sounds like we're about to enter a legal labyrinth, but I think we've covered a lot of ground already. Maybe we should pause here and pick up with those complications and exceptions in the next part of our deep dive.
I think that's a good idea. Give our listeners some time to digest all this information before we move on to the more intricate scenarios.
Great, so everyone stay tuned for part 2, where we'll delve deeper into the world of marshaling and explore those tricky situations where things aren't so black and white. See you soon.
Welcome back to LexTalks, everyone. So last time, we really demystified that whole concept of marshaling and explored all those ins and outs of Section 56 of the Transfer of Property Act.
Yeah. We talked about how marshaling is like a guardian angel for buyers out there, making sure they don't inherit someone else's debt burden unfairly.
Exactly. But just like a lot of legal concepts, there are always these tricky situations that make things a bit more interesting. And this is where we dive into those what-ifs that often come up in real-world scenarios.
Yes, those what-ifs can really make or break a case. So what's the first curveball that we're throwing at our listeners today?
Well, let's start with a situation where the prior mortgagee isn't just sitting around. What happens if they've already started the legal process of selling the property to recover their dues? Does the right to marshaling still apply?
That's a great question. It seems like things could get complicated pretty quickly if the legal wheels are already in motion.
You're absolutely right. In cases like that, courts have generally held that once the prior mortgagee has obtained a decree for sale, basically a court order, that allows them to sell the property, the subsequent purchaser might not be able to use the right to marshaling.
So timing is key here. The right to marshaling needs to be asserted before things get to the point
Of a court order. It's like a legal race against time.
Exactly. And it really highlights the importance of being proactive and diligent. When you're dealing with property transactions, you need to be aware of any potential prior mortgages and assert your rights promptly.
This is why having a good lawyer on your side is so important. They can help navigate all these legal complexities and make sure your rights are protected.
Speaking of complexities, what other tricky scenarios can kind of throw a wrench in the marshaling machinery?
Well, another common challenge comes up when we have a third party involved, someone who's not part of the mortgage agreements, but they have a legitimate interest in one of the properties. Imagine Mr. A in our previous example decides to lease out property B to a tenant. Now we have a new player in the game.
Okay, so now we have a tenant who's paying rent to Mr. A for property B, which is also part of this whole mortgage web. How does that impact the situation?
Well, now the courts have to consider the rights of this tenant as well. Remember, marshaling is all about fairness, and it can't be used to unfairly prejudice the interests of someone who wasn't part of the original mortgage agreements.
So it's not as simple as just saying, lender X, you have to go after property A first. Because property B has a subsequent mortgage. We have to think about the tenant who's actually living on property B and has a legal right to be there.
Exactly. The courts have to carefully weigh the equities of all the parties involved, including the prior mortgagee, the subsequent purchaser, and now this third-party tenant. It becomes a bit of a legal puzzle, and there's no one-size-fits-all solution.
It sounds like these cases could involve a lot of legal wrangling and arguments from all sides. It's no wonder that marshaling can be such a tricky concept to grasp.
It definitely requires careful consideration and analysis. But by understanding the core principles and looking at real-world examples, we can start to untangle those complexities. Now, there's another layer to this discussion that often causes confusion: the distinction between marshaling and contribution.
Yes. I remember we touched upon this earlier. Both doctrines seem to revolve around this idea of multiple parties having claims on the same property, but they're not interchangeable.
Right. You're absolutely right. It's easy to mix them up, but understanding the difference is really crucial, especially when you're analyzing case studies or tackling exam questions.
Okay, so let's clear up this confusion. What's the key difference between marshaling and contribution?
Well, marshaling, as we've been discussing, focuses on the rights of different mortgagees against the same property. It's about directing the lender to recover their dues in a way that's fair to all mortgagees involved. Contribution, on the other hand, deals with the rights and obligations among co-sureties who have jointly guaranteed a debt.
Co-sureties. Can you break that down a bit further for our listeners who might not be familiar with that term?
Of course, imagine someone takes out a loan and they need guarantors to vouch for their ability to repay. So they approach two friends who agree to be co-sureties if the borrower defaults. The lender can go after either of these friends for the full amount of the debt.
So it's like having backup singers for a debt. If the lead singer can't hit the high notes, the backup singers have to step in.
That's a fun way to think about it. Now, the friend who ends up paying the debt can then seek contribution from the other co-surety, arguing that they should share the burden proportionally.
So it's about splitting the responsibility fairly between those who guaranteed the debt, while marshaling is about directing the lender toward different properties to recover what's owed.
Exactly. The key difference lies in who bears the burden and how that burden is shared. In marshaling, we're dealing with multiple mortgagees and their claims on the property. In contribution, we're dealing with co-sureties and their obligation to share the debt burden.
That definitely clarifies things. Knowing the difference between marshaling and contribution will definitely help our listeners analyze legal problems more effectively. But let's face it, legal principles can seem like abstract concepts until we see them in action.
You're absolutely right. That's why case law is so important. Landmark judgments give us real-life examples of how these doctrines are interpreted and applied in court, providing valuable insights into judicial reasoning.
Yes, case law is like watching a legal drama unfold. It helps us understand how these principles play out in the real world. So are you ready to take us to court and explore some landmark judgments on marshaling?
Absolutely. Let's start with a classic case that's often cited in legal textbooks, Aldrich v. Cooper, a landmark English case from the early 1800s. This case really laid the foundation for our modern understanding of marshaling.
Ooh, an oldie but a goodie. I'm all ears. What were the facts of this case?
In Aldrich v. Cooper, a creditor had a claim against both the real estate and personal estate of a deceased debtor, and another creditor only had a claim against the personal estate. So the question before the court was whether the first creditor, who had two avenues for recovery, could be compelled to go after the real estate first, leaving the personal estate. For the second creditor,
It sounds like a classic marshaling scenario. Did the court side with the second creditor and enforce the principle of marshaling?
they did. The court, guided by the principle of equity, held that the first creditor had to exhaust their claim against the real estate first, preserving as much of the personal estate as possible for the second creditor. And this ruling really solidified marshaling as a crucial doctrine to prevent injustice in cases of overlapping claims.
It's a great example of how marshaling ensures fairness. Even when you're dealing with competing creditors, it forces the creditor with multiple options to take the path that causes the least harm to the other parties involved. Do you have any Indian cases that kind of showcase how marshaling is applied under the Transfer of Property Act?
There's a really fascinating case. From the Andhra Pradesh High Court, Subramania Iyer v. Muthia Chettiar decided in 1926. And this case presents a slightly different scenario, where a subsequent purchaser is seeking marshaling against a prior mortgagee, who has already obtained a decree for sale.
So this case touches upon that timing issue we discussed earlier. If the prior mortgagee is already a step ahead in the legal process, does the right to marshaling still hold up?
That's the question that the court had to grapple with, and in this case, they held that. While the right to marshaling does exist, it can't be exercised once the prior mortgagee has obtained a decree for sale.
So it reinforces that idea that timing is crucial. If you're a subsequent purchaser, you need to act quickly and assert your right to marshaling before the prior mortgagee gains a significant legal advantage.
Precisely. It emphasizes the importance of being proactive and diligent in property transactions. Now let's move on to another case that sheds light on the limitations of marshaling.
Yes, I'm curious to see a scenario where marshaling might not be the winning card.
Let's look at the case of Govindhari Khazar v. Shripad Narayan Kulkarni, decided by the Bombay High Court in 1959. In this case, the court refused to allow marshaling because it would have been detrimental to a third party who was not a party to the mortgage agreement.
So this case reinforces the idea that marshaling isn't an absolute right. It can be overridden if it would create
An unfair outcome for someone outside of that whole mortgage equation.
Exactly. It goes back to the principle of equity. The court has to look at the bigger picture and consider the potential impact on everyone involved, not just the mortgagees and the purchaser.
These case law examples are really helping to illuminate all the nuances of marshaling. It's fascinating to see how these principles play out in real-life legal battles. But before we move on, I want to circle back to the distinction between marshaling and contribution. Do you have a case that can really help solidify that difference in our minds?
There's the case from the Allahabad High Court in 1941, Gangadhar v. Ender Singh, which does a great job of clearly separating those two doctrines.
Perfect. Tell us more about this case. How did the court differentiate between marshaling and contribution? Well, the court highlighted that marshaling comes into play when a subsequent purchaser tries to prioritize the claims of a prior mortgagee against other properties. Contribution, however, applies when co-sureties are looking to share the burden of a debt that they jointly guaranteed.
So it all boils down to the players involved and their relationship to the debt and the property. It's like different legal teams playing on the same field, but following different rules.
That's a great way to visualize it, by understanding the roles of the parties involved and the nature of their obligations. You can start to see how marshaling and contribution operate in distinct legal realms.
This is incredibly helpful. I'm starting to feel like I could actually explain the difference between marshaling and contribution to someone without getting completely tongue-tied.
That's what we like to hear. And remember, the best way to really solidify your understanding is to delve deeper into these cases and analyze the court's reasoning. You'll find that seemingly complex doctrines like marshaling are actually rooted in the fundamental principles of fairness and equity.
I completely agree. Case law is like a treasure trove of legal wisdom. The more we explore it, the more we discover about the practical application of legal principles. Now, I have a question that's been bugging me. What happens when we have multiple subsequent purchasers involved? Or what if there are conflicting claims on the same property that go beyond that whole mortgage scenario? Does marshaling still fly?
Those are excellent questions, and they lead us into some of the more intricate and debated areas of marshaling. We're talking about multi-party disputes, conflicting claims, and legal puzzles that would challenge even the most seasoned lawyer.
Ooh, this sounds like a legal thriller in the making. But unfortunately, I think we're running out of time. For this segment, maybe we should save these complex scenarios for the final part of our deep dive.
I think that's a great idea. We've already covered a lot of ground, and our listeners could probably use a break before we delve into the most tangled webs of marshaling.
Sounds good. So stay tuned, everyone, because in the next part of our deep dive, we'll be tackling those mind-boggling marshaling scenarios that'll really put your legal skills to the test. See you soon. Welcome back to LexTalks for the final round of our marshaling marathon.
It has been quite a journey, hasn't it? We started by unraveling the basics of marshaling, dug deep into Section 56, and even got to see it play out in real court battles through some case law.
Yeah, we saw how marshaling can be a powerful tool for fairness. Making sure buyers aren't stuck with old mortgages, and everyone in these transactions gets a fair deal. But I have a feeling things are about to get even spicier as we explore those complex scenarios that we hinted at last time.
Absolutely. We're entering the territory where multiple parties and conflicting claims can make marshaling feel like high-stakes game of legal chess.
I'm ready to play. What's the first challenging scenario that we're tackling today?
Let's start with something that comes up a lot in practice. What if you have multiple subsequent purchasers involved? Let's revisit our example. With Mr. A and his 3 properties, he mortgaged all 3 to lender X, and then property C to lender Y. But now, let's say he sells property B to A, Mr. B.
Okay, so we have lender X with a claim on all 3 properties, lender Y with a claim on just property C, and 2 different buyers, one for each of the other properties.
It's getting crowded. So how does marshaling even work when you have multiple buyers?
Well, now that concept of prioritizing equities, it becomes even more important. Both Mr. B and the buyer of property C have a right to invoke marshaling against lender X. But they might also have to consider marshaling amongst themselves, depending on when they bought their properties. And the amounts involved.
It's not as straightforward as just saying, lender X, go after property A first.
Right. Now we have to figure out the rights of both buyers and figure out the fairest way to share the burden.
Exactly. It's a real balancing act. The courts have to look at the details, like the dates of the mortgages and the sale agreements, the amounts of money involved, and anything else relevant, to determine the most equitable way to apply marshaling in this multi-party situation.
I can just imagine these cases, leading to some heated courtroom showdowns. Are there any, like, guidelines or principles that courts use to figure out these complex marshaling situations? With multiple purchasers?
Well, one established principle is that subsequent purchasers who knew about the prior mortgage when they bought their properties have a weaker claim to marshaling compared to those who bought without notice.
Wait, so if you knew about the mortgage beforehand, you're less entitled to the protection of marshaling?
That's the idea. The reasoning is, if you knew about the mortgage when you were buying the property, you should have thought about that risk when you were making your decision. The law is more likely to protect those who were acting in good faith, unaware of those pre-existing burdens.
That makes sense. It prevents someone from, buying a property with a mortgage on purpose.
Yeah.
And then trying to use marshaling to get a free pass. So make sure the doctrine is used for fairness,
Yeah.
not to reward those who are trying to play the system.
Exactly. It's about applying that principle of equity in a way that's just and practical. Now, let's switch gears for a bit. What happens when we have conflicting claims on the same property? But it's not a typical mortgage situation. Does marshaling still apply there?
That's a great question. We've been talking about mortgages this whole time.
Yeah.
But can marshaling be applied to other types of property disputes?
It definitely can. Marshaling isn't just limited to mortgages. That main principle of pushing a claimant toward a less burdened asset can be used in all sorts of disputes, like those involving inheritance, property settlements, or even claims from contracts.
So it's a multi-purpose legal tool that can be used in a bunch of situations to make sure things are fair. It's like a legal Swiss Army knife.
That's a great way to think about it. But like any powerful tool, it's super important to use it wisely and understand its limits. And that's where a deep understanding of case law becomes essential.
I totally agree. Our marshaling journey wouldn't be complete without acknowledging the importance of case law. It really shapes and refines this doctrine by studying how courts have applied marshaling in different situations. We get valuable insights into how it's used in the real world and all the nuances that make it such a fascinating legal concept.
Absolutely. Case law is our guidebook, our compass, in the often unpredictable world of legal disputes. Through case law, we learn to apply legal principles in a way that's effective and fair.
I feel like we've covered so much ground in this deep dive. We started with something that seemed really complicated and intimidating, and now I feel like I can actually explain marshaling to someone and even discuss how it applies in different cases.
That's what we strive for at LexTalks, to make these complicated legal concepts easy to understand and approachable. And remember, learning doesn't end here. Keep looking into case law. Talk about it with your classmates, and don't be afraid to question what you think you know. The beauty of law is that it's always changing, so stay curious and stay informed.
Well said. A huge thank you to our expert for guiding us through this marshaling maze. I'm sure our listeners feel way more prepared to tackle any marshaling problem that comes their way.
It was my pleasure. And to all our listeners out there, thanks for joining us on LexTalks. We hope you found this deep dive insightful and maybe even enjoyable. Don't forget to subscribe and stay tuned for more simplified legal insights.
Until next time, happy lawyering, everyone.